Garima has been fighting for her rights with her siblings for the past 8 years. She has been fighting with both her brothers since their childhood days, but that fight was different. After her father passed away, both her brothers refused to give Garima a share in the family property. There is a similar legal battle over property in millions of families in the country. According to the national judicial data, there were 4.42 crore pending cases in the country until September 2023. An estimate suggests that 2/3 of these cases were related to land disputes. It takes many years to resolve such cases. There are large-scale campaigns running at the government level to promote daughter safety. However, it is still not clear whether a daughter will get a share in her father's property or not. Such cases become complicated due to different decisions made by different courts in the past. How much and when does a daughter have rights in her father's property? If it is ancestral property, how much share will she get? What rights does she have in her father's property after her marriage? These are some questions that are beyond the understanding of ordinary people. The Delhi High Court has said in a judgment that an unmarried or a widowed daughter is entitled to her father's property, but a divorced daughter, on the other hand, has no rights to her father's property. After this decision, there has been a new debate over the rights of daughters in paternal property. So, what does the law say? In 2005, changes were made to the Hindu Succession Act for the protection of daughters' interests. The new law considers daughters as equal shareholders in the ancestral property. Whether she is married, widowed, unmarried or separated from her husband, she becomes a shareholder from birth in inherited property. But the condition was that a woman's father should be alive until September 9, 2005. In this situation, the woman or the daughter can claim her share in ancestral property. If the father dies before this date, then the daughter will not get a share in the ancestral property. However, the distribution of self-purchased property by the father will be done on the basis of a will. Even after changes made in the Hindu Succession Act, some things are still unclear. For example, in 2020, Supreme Court of India said in clear words that even if the father died before September 9, 2005, the daughter would still have the same rights over the ancestral property as her siblings. If the father has not written any will, then the daughter will have equal rights in his property. At the same time, if a person living in a joint family dies without writing a will, his daughter will have equal rights along with his sons on the property. According to Supreme Court lawyer Anil Karnwal, daughters have an equal right in their father's ancestral property. Irrespective of the year of their father's death, the father's self-acquired property can be given to anyone he wishes. If the father has not written a will, then the daughter has an equal right on his property. In a joint family, if a person dies without writing a will, then his daughter also has an equal right on his property just like his sons. However, if the father does not want to give a share of his self-acquired property to his daughter, then the daughter cannot make a claim on it. If the father dies before writing a will, then the daughter can claim her share. It is important to make a will to avoid disputes over property distribution in families. Please write clearly about who should get how much share by making a will. You can save your family from situations.